Well, welcome everyone. Today we're going to be discussing the upcoming changes to casual employees that are set to take effect as of the 26th of August 2024. Just by way of introduction, my name is Peter Hindeleh. I'm the Solicitor Director of Bentham Legal. Bentham Legal is a employment law specialist firm operating here in Sydney, Australia. However, we deal with all jurisdictions throughout Australia. So it may not be immediately apparent, but casual employees have been driving industrial relations reforms for the better part of 10 years. However, it's longer than that. And during our presentation today, what I wanted to go through is the different events which have influenced changes to the definition of casual employee before having a look at some of the more recent amendments that will take effect. And so we really start all the way back in 2001 with the High Court's decision in Hollis and Varbu. And this is an often cited decision, but what it's most famous for is introducing a test called the multifactorial test. In other words, to determine the true nature of a relationship between two parties, you don't just look at their contract, you have a look at the relationship as a whole, and you almost take a shot or take a guess to determine what the true relationship is. And so that multifactorial test was good law for a very long time. And still is, actually. But it was predominantly brought up when looking at casual employees in the Federal Circuit and Family Court of Australia's 28th decision of WorkPac Pty Limited against Skeen. And in that matter, Mr. Skeen was a casual employee, but sought to argue that his employment resembled that of a permanent employee, and went to court to argue it, and the court agreed with him. The court said, look, Mr. Skeen works regularly, he does the same role as full-time employees, and so we also believe that Mr. Skeen should be a full-time employee, and WorkPac, you're required to pay back Mr. Skeen's permanent entitlements, such as annual leave and any time that he had off as personal leave. Well, Mr. Rosato, who coincidentally also worked at WorkPac, and I'm sure was a very keen legal mind, read the federal courts or Federal Circuit and Family Court's decision in Skeen and said, well, my circumstances are exactly the same. I'm a casual employee, but work full-time hours and do the same job as permanent employees. And so he wrote to WorkPac and said, well, I believe that I'm a permanent employee and I would like you to start paying me as a permanent employee and receiving the benefits and entitlements of a permanent employee. Now, instead of dealing with this matter at a workplace level, WorkPac actually approached the Federal Circuit and Family Court and sought a declaration that Mr. Rosato was not actually a permanent employee, that he was a casual employee. And in support of that declaration, WorkPac provided a guarantee, one, that if Mr. Rosato is found to be a permanent employee, then all his entitlements will be paid to him immediately. And two, not many employment lawyers know this, but WorkPac actually guaranteed or indemnified Mr. Rosato for all legal fees. In other words, they said to him, you can get a lawyer and we'll pay for the lawyer, but we want this to be assessed. So I don't think they were very happy with the Federal Circuit and Family Court's decision that was just handed down, and this was their opportunity to challenge that decision without having to appeal it. But nevertheless, appeal it they did, because this matter went all the way up to the High Court. And the decision is quite interesting. I encourage anyone to have a read of it. But paragraph 97 of the court's decision is quite telling, because the court didn't give a view as to what test should be applied when it comes to determining whether an employee is casual or not casual. But instead, what the court did was look at Hollis and Varbu and said, well, we actually still like the multifactorial decision, the multifactorial test. But something that is often neglected when it comes to determining based on a relationship whether someone is a casual employee or not a casual employee is the label that they've given to themselves and have entered into under an employment contract. So that's something which ought to be considered. Well, this did not provide employers with a tremendous amount of assurance, because by and large, the court didn't provide any clear guidance. They instead said, well, we still think that the multifactorial test is good law, and that if somebody enters into a employment contract with the label of casual, then you need to consider that as a very, very persuasive factor. And so the then Morrison government was lobbied, and the Morrison government said, well, we want to address this uncertainty that the High Court has introduced as a result of the WorkPac decision, and so introduced a new section of the Fair Work Act, and that's Section 15A, which provides employers with a definition of who a casual employee is. And this clause more or less has been referred to as the contractor's king clause, because it provides that if a individual enters into a contract that makes very clear that they're a casual employee with no firm and they receive no firm advanced commitment to continuing an indefinite work, and they accept that offer of employment, knowing very well that the employer cannot guarantee continuing an indefinite work, then that person, regardless of the other characteristics of their relationship, is a casual employee. Well, that addressed a lot of uncertainty that employers had. And now they have assurance that, well, if I enter into a contract with a worker and the contract says that worker is a casual employee, then I can rest knowing that that's not going to be challenged anytime soon. Well, the Morrison government was voted out of office, and the Albanese government came in, and one of or something that they did was introduce a raft of amendments to the Fair Work Act. But when it came time to addressing who is a casual employee or not, what the Albanese government sought to argue very well was that this contract is king principle, further perpetuates unequal bargaining power. Here you have an employer who is offering work and an employee who is desperate for work, but if the only jobs that are being offered are casual in nature, well, then the employee doesn't have much of an opportunity to give their opinion on that, irregardless of the fact that the employee may down the line seek more stable work in the same workplace. And so there were two rafts of amendments introduced to the Fair Work Act, and these are called the Closing Loopholes Before Bills, now Acts, because they've been ratified. And the Closing Loopholes Act number 2 introduced the majority of changes to the definition of casual employees, as well as changes to when a person is able to request conversion to permanent employment, rather. And those are the changes that I want to get into today. So the first is the changes to the new definition of casual employment and changes to Section 15A of the Fair Work Act. Now, as of the 26th of August, gone will be a clear definition of who is a casual employee or not. And instead, Section 15A will reflect a general rule, right? And so, I guess, for lack of a better word, generally, if you have a worker who adheres to these circumstances, then they'll be deemed to be a casual employee. But any worker who deviates from these general circumstances can very well be a permanent employee. And so those rules, one is tricky and one is quite clear. The first rule is that the employment relationship is characterized by an absence of a firm advanced commitment to continuing and indefinite work. And we're going to get into the test for determining whether there is an absence of continuing and or advanced commitment to continuing and indefinite work, rather. The second is whether the casual employee is receiving a casual loading and a specific rate of pay. That shouldn't be too controversial. If a casual is receiving a casual loading, then it's more likely than not that they'll be a casual employee until it's challenged. But that first test, how can you determine whether a relationship is characterized by an absence of a firm advanced commitment to continuing and indefinite work? Well, you have to actually look at not only the relationship as a whole, but also the workplace as a whole as well. And so something that we as practitioners will look at is an employer's ability to offer work, the future availability of work, whether a casual employee is undertaking the same role and the same duties as permanent employees, and also, quite frankly, how often is the casual employee working? If they're working the same hours as full-time employees and they've been doing that for a number of months now, well then the question will inevitably arise, can an employer actually guarantee continuing and indefinite work, or do they just not want to? And so for employees who say to themselves, well, I've been with my employer now for 6 months, for 12 months, and I believe that at this time I am a permanent employee, or that my employer is able to provide me with permanent employment, well then there will be new casual conversion mechanisms introduced to the Fair Work Act and taking effect from the 26th of August. And here they are over here. Now, any casual conversion request lays with the employee. The employee needs to write to their employer and request conversion to permanent employment. Now, an employee's request will only be valid if they meet 4 criteria. And I've got that criteria up on the screen. The first is that the employee is not in a current dispute with their employer about casual conversion. So hopefully, check. The second is that the employee has been employed with their employer for at least 6 months if you're not a small business employer, or 12 months if you are a small business employer. And so this is often described as the minimum employment period anyway, or probation. So in other words, has the employee completed their relevant probation period or their minimum employment period? The third is in the 6 months leading up to the casual conversion request, has the employee received a response from their employer? And so what we want to hopefully avoid is an employee getting a no from their employer in response to their request, and then lodging that same request 1 week later, and it's just a vicious cycle. The fourth is, has the request been dealt with by the Fair Work Commission? If an employee is able to satisfactorily answer no to each of these conditions, well then the employee will be allowed to write to their employer and request conversion to permanent employment, and the employer has 21 days from the date of receipt of that request to provide a written response. And if there is a further dispute with respect to this request, then the Fair Work Commission will actually have the ability to arbitrate those disputes. Now, one of the final changes to casual employees is the introduction of a new casual employment information statement. And this statement will provide employees with the new definition of who is a casual, and also provide some information as well on the casual conversion request. But for employers in particular, the new amendments to the Fair Work Act require employers who aren't small business employers, so employers who have 15 or more employees, to provide a copy of the casual employment information statement as soon as practicable after the employment starts, and then provide it again to all casual employees 6 months from the commencement of their employment, then 12 months after the commencement of their employment, and each 12-month anniversary thereafter. Now, small business employers don't have to provide the casual employment information statement at the 6-month or the 12-month anniversary, but will need to do that as soon as practicable after the employment starts, or before and after the employment starts, rather. And what's the purpose of this information statement? Well, I think it's to keep employees appraised of their rights, as well as changes to the Fair Work Act that they might not be otherwise aware of. And this is meant to be done periodically so that employees are constantly kept abreast of any amendments to the Fair Work Act. So what can we do as employers to prepare for this? Well, one, we need to update our contracts to make sure that the old definition of casual employee isn't in there. We also need to make sure that in our contracts we make very clear that the employee acknowledges that there's no advance commitment to continuing and indefinite work. But having said that, that term will not be definitive as it was before. It still will depend on the work environment that the employee finds themselves in, but it's still important to update the contract nevertheless. The second, and something that I've been recommending to all our clients here, is to actually have a new casual conversion policy in place so that if an employee wants to write to their employer requesting conversion to permanent employment, well, there's a policy there, there's a procedure there, there's an allocated person who will receive that notification and will be able to actually deal with that notification within the 21-day period. And then finally, have it marked in your calendars. As soon as you have a casual employee begin, mark the 6-month anniversary, mark the 12-month anniversary, and make sure on those days that employee is getting their casual employment information statement. That is crucial to really demonstrating that you are compliant and that you have provided employees with the notice that they need so that they're kept aware of their rights and entitlements under the Fair Work Act. Well, thank you very much for listening. And for anyone who wants some further information or advice, then I have my mobile number up on the screen. You can also visit us at www.benthamlegal.com.au. We have a range of resources as well as further information. And if you want to be kept up to date with new legal definitions, new legal definitions under the Fair Work Act, rather, then you can follow us on Instagram and also LinkedIn. We try and post there as often as we can, and we try and provide anyone who follows us with new legal definitions of key terms which often come up in employment law, as well as further information on changes to the Fair Work Act. Well, thanks everyone for listening, and hope to hear from you soon.